Hi, it's Mike DelSignore. I'm outside the Falmouth District Court, and the door of the court is right behind me. That's where you would head if you had an arraignment in Falmouth District Court for an OUI offense. And in this video, I want to explain to you the court process of what you can expect when you're charged with OUI for the first time. So, an OUI case starts with the first court date, the arraignment. You'll be formally notified of the charges. You'll enter a not guilty plea, and the court will then set the next date down for a pretrial hearing. So first thing you need to know, first court date is your arraignment. It's not the trial. You'll be released if it's your first offense on your promise to reappear at your next court date. So generally the arraignments are fairly quick. You do have to wait for the court to process the paperwork and to call the case, but you'll only be in front of the judge for probably 30 seconds. One thing that I like to do when I'm at an arraignment is I do like to do a motion to preserve any video evidence. Most people look good in booking videos or any type of video that the police may have. So you want to do a motion to preserve these videos because they sometimes get taped over, lost, or recorded. And if that happens, then you may be able to get a further remedy from the court. I've had cases dismissed. I've had breathalyzer evidence dismissed or other evidence excluded from the case based on a police department not complying with a judge's order to keep a video. So first thing, you'll enter a not guilty plea, you get another court date. You'll get a copy of the police report generally. When I get a copy of the report, I'll be able to review the case, go over it with you, and then make an assessment about what your best options are to handle this case. Is this something you're going to resolve? Is this something we want to fight? Do we need more information? And a lot of times we do. Sometimes, at the first court date, the government won't have all the reports. There'll be video evidence that they won't have access to immediately. Typically, it takes at least a month to get any video evidence. And you might have other records that I'll want to review. Let's say you hurt your knee, back, or have issues with balance. We'll want to get a copy of those medical records and potentially use those during your case. So you were likely given a field sobriety test by the police officer. And that test they're going to use to say that you were under the influence of alcohol. They're going to say because you missed heel to toe, because you didn't keep your foot up for as long as they wanted, that was because of alcohol. Now, medical evidence could be used, and I've used it many times, to suggest that there are other reasons why your balance wasn't so great, such as a prior injury. So we want to get these records to give a fuller picture to the judge or the jury about why the officer's opinion may be incorrect in the case. So as part of the evaluation, I'll look at all the parts of the case. Generally, in an OUI case, you have three parts. You have the driving, you have field sobriety test, and then you have the officer's observations when the officer comes up to the side of the window. So let's start with the driving. What we want to do is we want to minimize any claims of unsafe or erratic driving. So if you're stopped for a marked lane violation, we want to suggest that, well, the officer might have been behind you for a mile and only saw one or two lane violations, suggesting that maybe you were adjusting the radio, maybe you were on the phone, maybe it was just a momentarily you were distracted. So we look at the driving in order to sort of make an argument that this driving isn't reflective of someone under the influence of alcohol. If there's a 911 call, which often there is, sometimes we'll be able to challenge whether there was even a legal basis to stop you. In other words, just because someone calls 911 and says they think someone is driving erratically or unsafely, it doesn't mean that an officer has a right to stop you. That information has to be trustworthy and reliable. So there are legal issues sometimes in OUI cases that can result in the case being dismissed, or, as is very commonly the case, resulting us getting more information to help prepare your case for trial. So, for example, I do a lot of motions to suppress, and while we have some of them granted, a lot of them are denied. But in those cases where the motions are denied, we have the officer testify under oath, and we get more information that we wouldn't have otherwise have, so it better prepares us for trial. So a purpose of a motion hearing is A, to win the motion, and that happens in many cases, but in a lot of cases we file the motions anyway just to get that officer on the witness stand in order to find out what he's going to say during your trial. So it's an important part of the preparation of the case. So when you think of an OUI case, there's there's really three parts to it. You got the arraignment, your initial part, and then any motion, stage, and then trial. And anywhere along that way, you can resolve the case and say, hey, I don't want to fight it. And clients sometimes plea for a lot of different reasons, to get back on the road, or because the case is strong from the government's perspective. But you need a lawyer to help you decide what the best options are for you. So if there aren't any legal motions, then your next step would be to trial if you're going to fight the case. Now, what happens, let's talk about what happens if you want to resolve the case. So and a lot of this is going to be dependent on whether you can get a ride while we're fighting the case. So let's say you took a breathalyzer, your license is suspended for 30 days. After 30 days, you can get your full license back. If you refuse the breath test, it's suspended for 6 months. So I'm going to take the refusal situation first. You refuse the breath test, and you're in a situation where you don't have anyone to get you to and from work. You want to get back on the road as fast as you can. Step one, you could appeal the refusal. That's difficult to win. Step two is that you would resolve the case. If you plea out, you have the ability to get a hardship license. So you get a continuance without a finding. That's the plea on a first offense, OUI. You have to do a program. Your license would be suspended for 45 days. But with a letter from work, you'd be able to potentially get a hardship with the Registry of Motor Vehicles. Second scenario is you took a breathalyzer, so your license is only suspended for 30 days. After 30 days, you can get your full license back. If you want to get back on the road immediately, we could try to advance the case. If you plea out, your 30 days ends. A new 45 would start, however, but you'd be eligible for a hardship license on that. So that's the two license scenarios. I know they can be confusing, so feel free to call to ask further questions, or send me a text message. My number is 781-686-5924. So those are your two license scenarios that typically people face. If you refuse the breath test and you're found not guilty, there's a presumption of reinstatement of your license on the 6-month refusal suspension. If the case takes longer than 6 months for some reason, then you can get your full license back even if the case is still pending. So if you took a breath test, and people ask this all the time, well, how do I win the case? What can we do? Well, we can try to file a motion to exclude the breath test from evidence. These breath tests are not infallible. There's a lot of problems with them. They're often inaccurate, unreliable. So don't assume you can't win a case just because you took a breathalyzer. There's no hurry to take a plea on a first OUI, other than possibly getting back on the road right away. But as far as your resolution of the case, it's not going to change when you do the case, when you resolve it. Judges typically don't punish somebody for going to trial on a first offense, OUI. You'll typically get the standard 24D fines and fees, 1 year probation. So that's the basic information, what you need to know if you're charged with an OUI. Keep in mind your first court date, that's not your trial, it's an arraignment date. You're going to be given a police report. Don't be in a hurry to resolve these. Understand that I handle these every day in courts throughout Massachusetts. These are winnable cases. You're being charged based on an officer's opinion, and that opinion often can be unreliable. It's subjective. Who's to say you weren't tired rather than under the influence of alcohol? These field sobriety tests, they're not indicative of somebody under the influence of alcohol. Most people can't do those if they've consumed no alcohol at all. And understand the legal issues in your case. I've had some very difficult cases dismissed based on legal issues. So I had a case where someone was driving on the wrong side of the highway, dismissed, legal issue. Third offense, OUI, dismissed. The police didn't have a reason to stop the person. So don't rush into a resolution of the case. I do have clients that want to resolve the case, and we do that all the time, but just do it knowing the full consequences and knowing it with all of the information. If it's not your first offense, then there'll be additional license loss and license consequences. We have other videos on our channel if you're not a first offender, second offense, and you can call and ask any of those questions. So my name's Mike DelSignore. I'm here to help you. My passion is help people charged with OUI offenses. It's never too early, too late to call. If you want to reach me, the best way just to pick up the phone or text me at 781-686-5924.